Hello, everyone. My name is Cliff Davis. I'm a shareholder with Roberts, Markel, Weinberg, Butler, Haley, and I'm here today to talk with you all about judicial and non-judicial foreclosures and foreclosure in general. This is going to be kind of a 30,000-foot view of foreclosures, and you can type in your questions, I believe, while we're talking, and we will hopefully have some time at the end to answer some of those questions. Specific questions. So some of the things we're going to talk about today are terms, non-judicial foreclosures, judicial foreclosures, and pitfalls. And the first thing we're going to talk about is judicial foreclosure, which judicial foreclosure means it's a foreclosure sale that is administered by a constable or sheriff pursuant to the authority granted in a judgment. So what that means is a judicial foreclosure happens after a lawsuit is filed and a judgment is obtained. So all of these, when we talk about judicial, means that the association has a judgment in their hand when they proceed with foreclosure. We'll also talk a little bit about non-judicial foreclosure, which is a foreclosure sale conducted by a trustee. And so a non-judicial foreclosure is something like a lender does. Condominiums use them. Some non-condominium associations use those. And where a judicial foreclosure is conducted by a sheriff or a constable, a non-judicial foreclosure is conducted by a trustee, which means typically the association attorney actually goes down there and sells the property. And we'll dig right into judicial foreclosures. So the first thing you have to do is obtain a judgment, but there's some steps you have to go through before you obtain the judgment. You know, most associations go through some type of a demand letter process for delinquent assessments that ends with the Chapter 209 letter, which is Chapter 209 is a reference to Chapter 209 of the Texas Property Code. Section 209.064 of the Property Code states that before you can turn a matter over to a collection agent, including attorney, the association has to send a letter that has some specific requirements. The amount due, it gives everybody 30 days to pay. We believe that that letter should contain an itemization of the amount due. You have to inform the owner that they are entitled to a payment plan, and all they have to do is ask. And if they ask, you have to give them a payment plan that's in accordance with your payment plan policy, which for most associations, the law requires that the board have adopted and filed a payment plan policy. If you don't get a payment in response to your Chapter 209 letter or a payment plan, that's when the board turns it over to the attorney. The attorney sends at least one, if not two, demand letters. Some may send more. If the attorney doesn't get a response to those demand letters, the next step would be to file a lawsuit. And the lawsuit is a petition that's filed that requests the remedy of foreclosure in most cases. Once that lawsuit is filed, it has to be served on the owner. Once it's served on the owner has more or less 30 days to respond to that lawsuit. And how you proceed depends on if the owner files a response or not. You see here there's a bullet point for dispositive motions, agreed motions, payment plans. Most collection lawsuits are resolved in one of three ways: an agreed judgment, a summary judgment, and a default judgment. A default judgment means you sued the owner. They did not file a response to the lawsuit in the proper time frame. So you file a motion with the court and you say, we sued them, we served them, they didn't respond, we should win. And that's called a default judgment. Summary judgment means that you sued the owner with the lawsuit, filed the lawsuit, served the owner with the lawsuit, and they filed a response to the lawsuit. At that point, you file a motion for summary judgment with the court, or you can, that says we sued them, we served them, they filed a response, but judge, there's nothing for you to decide. There's no fact, question, and issue. We should win without a trial. And you know, collection cases are usually fairly easy. The declaration says the owner has to pay money. They don't pay it, so there's nothing to decide. They've got an obligation to pay, they haven't paid. You show the declaration to the judge, show them the obligation, an affidavit's filed saying that they haven't paid, and the judge grants a motion. So that's a summary judgment. And like I said, most of these collection lawsuits are going to resolve one of those three ways. Typically with an agreed judgment, there will also be a payment plan attached there too. You know, some owners want a payment plan without a judgment, but after we file a lawsuit, we believe the best way to proceed is to make them sign a judgment so that if they default on the payment plan, you don't have to start the process over. Some cases actually go to trial. There may be reasons for this. It's typically not a smart move for an owner to go to trial unless there's some kind of special circumstance. I mean, if they haven't paid, they haven't paid, and all a trial is going to do is make this more expensive. So once we have the judgment, no matter which type it is, you have to wait about 30 days for that judgment to become final, and then you can proceed with posting the property for foreclosure. Judicial foreclosure is typically used by non-condominium associations, but there are some condominium associations that use those. And as just kind of as a reminder, the difference between a condominium and a non-condominium is in a condominium, the owner owns the airspace within their 4 exterior walls. In a non-condominium, they own the dirt underneath the property. And the reason that I kind of say condominium and non-condominium is because there are some associations that may be called a townhome association, like the Devonshire Townhome Association, that may actually be a condominium. And then there's some townhomes that are not condominiums. So you really have to look at your documents to determine if you're in a townhome association, is it a townhome, a non-condominium development, or is it a condominium development? And one more word on this. You know, one of the most important things I may say today is that after an association sends a 209 letter, before it's turned over to the attorney's office, the matter, the property code requires that the authorization to pursue foreclosure be approved by the board in the open session of a properly noticed meeting. And this is something where a lot of associations kind of fall down, and we need to make sure that you are approving turning matters over to the attorney in the open session of a properly noticed meeting. And there's several ways to do that. And if you need help with that, I'll give you my email at the end of the presentation, and I can provide you with a memo on how to properly document turning a matter over. We'll go on. The final judgment. So when you foreclose on a property, you can foreclose on the amounts that are secured by the lien on the property. So in the declaration, it will say, it will tell you what amounts are secured by a lien on the property. Typically, the assessments are always secured by the lien. Typically, interest and collection costs are secured by the lien. You want to make sure that attorney fees are secured by the lien. You know, in a lot of cases, the fight really isn't about the assessment. It becomes a fight about the attorney fees. So when we file a lawsuit, we have to separate out and tell the court, these amounts are secured by the lien, these amounts are not secured by the lien. Typically, amounts that are not secured by the lien might be deed restriction attorney fees that are due on the account, or late fees, or fines if you've got fining authority and you've levied fines. And what that means is you cannot foreclose on unsecured amounts. You can only foreclose on secured amounts. And that's very confusing to owners. You know, we have a lot of owners where we post them for a foreclosure and they go down and pay the constable or sheriff to stop the foreclosure. And they think they've paid in full. Well, if the judge has awarded unsecured amounts, those were probably not and should not have been part of the money collected by the constable. The constable should only be collecting the secured amounts. So an owner may go down there and pay a constable $4,000, but it turns out they've got another $500 to $700 or whatever it is in unsecured amounts that remains due and owing and is part of that judgment. And again, that really confuses owners. A lot of times they don't understand the difference between a secured and an unsecured amount. So those amounts are in part of the judgment. The attorney fees are awarded in the judgment. And again, hopefully the declaration says that they are secured amounts. We have a number of associations where the attorney fees are not secured. And, you know, again, that's a lot of times that's the biggest expense. So that can create an issue when you go to foreclose. And a large part of the judgment cannot be part of that foreclosure. The judgment will contain language that specifically says that an order of sale may issue, and that's the magic language to where when we get the judgment, after 30 days, we send a letter to the clerk's office and say, hey, we've got a judgment on this date, we need an order of sale. And they issue a document back to our office. That document is sent to the constable. And then the constable posts the property, notifies the owner that the property is posted. Let's go on a little bit. So post-judgment, there's some things you can do to try not to incur that cost of foreclosure, and one is send a post-judgment demand letter. Our office typically sends a post-judgment demand letter to try to get the owner one more time the opportunity to pay or get on a payment plan before the association invests the money to post the property, which that can be $1,000 to $2,000 itself, getting the property posted. And if a lot of times that money is not in the judgment, so it's an additional money that you're going to have to try to collect from that owner at some point. If we post a property and the owner comes and says, well, I want a payment plan, we include not only what's in the judgment, but any of those post-judgment fees. We try to put them in that payment plan so that the association can get paid back in full. You'll see on number 3 there is an abstract of judgment. That's something we file after we get a judgment, and basically what that is a document that's filed with the county that puts the public on notice that a judgment has been entered against this person. So when somebody goes to refinance or sell their house, if they haven't already paid that judgment, the title company will search the real property records. They'll find that abstract, and then they'll contact the association and say, we need a payoff on this. They typically will not lend money for someone to buy or refinance a house if they find a judgment out there. And the way they find that is by searching the county records for the abstract of judgment. The last remedy is foreclosure. If you write a post-judgment demand letter and they don't respond or they don't contact you, when a judgment's signed, the court sends a notice to the owner and says a judgment was signed. And sometimes that'll prompt the owner to contact the office or contact the association and say, hey, I see a judgment was signed against me. Can I get on a payment plan? So that's how some of these resolve themselves post-judgment. But if you don't get that payment plan, if they don't respond to the post-judgment demand letter, the last remedy is actually posting the property for foreclosure. So the pre-foreclosure process, I already talked about that a little bit. We request what's called an order of sale. It's a formal document that's prepared by the clerk's office. It states in there the description of the property, the location and the time of the sale, the amounts awarded in the judgment that has to be paid. We take that document, send it to the constable, they post it, they send a notice to the owner that the property is going to be sold at a foreclosure sale. When we find out a property is posted, we mail, and by certified mail and regular mail, a copy of the notice of sale to the owner. We also hand deliver that to their property too. And if they don't answer the door, we have the server tape that to the door. We're trying to get notice to them in as many ways as possible. The constable's notifying them, the attorney's office is notifying them by mail. If the attorney does what we do, they're hand delivering a copy of that. We're trying to get that owner to come out of the woodwork and take care of this thing. Pre-foreclosure, the sale of real property. This recites the statute that says that foreclosure day in Texas is the first Tuesday of the month. It happens between 10 o'clock and 4 o'clock. So typically at 10 o'clock in the morning on the day of foreclosure sale, that's when the constables start their sales. And in Harris County, they usually start with association foreclosures first. The practice kind of differs depending on what county you're in and what their practice is. The notice of sale is the document that the constable sends to the owner. And again, that's something that tells them when the property is going to be sold, how much they owe. It has to be published. So for example, in Harris County, there's a paper called the Daily Court Review where legal notices are published. It gets published in there. In some counties, it gets published in some other type of a paper of local circulation. The expenses for that can vary wildly. In Harris County, it's $265. In Montgomery County, it may be over $1,000. And a lot of times, those are expenses that are not included in the judgment. And so, it becomes a collection issue on those costs too. So if the constable takes care of publishing, they will collect that cost. If publishing may be a separate entity where the constable sends it to the paper, but they don't pay the cost, and the paper bills you directly, bills the association directly, typically through the attorney's office. And so that's another cost that's out there. And if it's billed directly to the association, the constable will not collect that publication cost. On the day of the sale, like I said, at 10 o'clock, the sheriff starts auctioning off properties. It's kind of a madhouse. If you don't really know what's going on, it's hard to tell what's going on, and there's not a lot of direction given. They just start. Some sheriffs will start the bidding off at the amount of the judgment. Some will not. Some started at what's called the constable cost, which is typically the posting publication, their service fees, and then the constable adds a little fee in there that they take from a foreclosure sale. So, you know, if they started off a judgment amount, that's good, because if somebody bids, that typically means the constable is going to take their cost and then send the judgment amount to the association. If there's anything above that, it's called excess proceeds, and that money actually belongs to the foreclosed upon homeowner. The constables take place at the courthouse steps. Now, that's what the law says, but really, in reality, a lot of counties have now a designated place where the foreclosure sales take place that may not be at the courthouse. In Montgomery County, they have a room in a county building. In Harris County, they actually rent out an event center, and they have the foreclosure sales there. At the sale, the property can be sold to a third party, the association, or if nobody bids on it, there's no sale, and you're kind of back where you were when you started. You've got a judgment, but you've tried to collect that judgment, but nobody bid on it. And so it's still in the name of the owner. If the association, in some cases, will instruct the attorney or whoever's handling the sale on their behalf that they want that person to bid up to the amount of the judgment, because the goal is to collect that judgment amount. And so the association may bid on the property. Now, obviously, the risk there is once you start bidding on a property, you may win the auction. And most associations don't want to own the property, because then you've got a whole nother set of headaches to deal with if you do. Third party may bid on it. If they do, they have to pay the constable, hopefully right then and there. That kind of differs by constable offices. Some offices will make you pay right at the time of the bid. There are some that give owners until 2 or 3 in the afternoon to bring the money. And obviously the problem with that becomes sometimes the owners decide, you know what, I bid on that, but I really don't want it. And that puts the association in the position of having to pay the money to try to get that property posted again. Preferably the constable or sheriff in the county is taking the money at the time of sale and not giving people the opportunity to back out of the sale. So when you buy a foreclosure property, you're buying that as is. Foreclosure sale buyers have very few rights. So they've got to know what they're doing. And my experience is that most of them down there do not know what they're doing. They think they're buying a house for $5,000 or whatever it sells for, when in reality they are buying that house, and they'll get a deed that says they own it. But if there's a $200,000 mortgage on it, if somebody doesn't pay that mortgage, the mortgage lender is going to foreclose at some point, and there may be taxes due on that property. If those don't get paid, the taxing authority is going to foreclose on it. They don't care about the association foreclosure. If they don't get paid, they're taking it, and in many cases, they don't even notify the foreclosure sale buyer that they are coming in behind and taking that property. We have had cases where the association foreclosure happens in the morning, and somebody buys it, and in the afternoon, the lender forecloses on it. Or the next month, the lender forecloses on it. And we typically get a phone call then, and they say, hey, I made a mistake. I want to get my money back. And at that point, it's too late. They are out that money. So, if you're going to buy properties at a foreclosure sale, you've really got to know what you're doing and be able to research mortgage liens on the property if there's taxes due on the property. After a foreclosure sale, the owner still has the opportunity to get the property back. So if the property actually sells, the association is required to send a notice to the owner by certified mail telling the owner that, hey, your property sold on this date at approximately this time, and you've got a right to redeem the property. And then when you send that notice, you've got to file an affidavit with the county stating that you sent the notice. So that notice gives the owner 180 days to redeem the property. And I think we'll talk about that a little more on the next couple slides. Like I said, 180 days to redeem the property. It's 180 days starting with the date the notice is sent. You also have to send that post foreclosure notice to any lien holder that's filed a deed of trust on the property. So what that means is, obviously, if a property sells, you've got to obtain a lien holder report from a title company. That's another cost. An attorney or somebody has to review that to determine what lien holders get notice. And you send that right of redemption letter, is what we call it, to the owner and to any lien holder entitled to notice. And then you just kind of sit and wait for that 180 days to see if any of those, if the owner or a lien holder contacts you and says they want to redeem it. It happens, doesn't happen a lot, because when they do, and as we'll talk about on the next slide, if somebody does want to redeem the property, at that point, the owner has to pay the association pretty much everything. The judgment amount, interest, cost, attorney fees to get it to foreclosure. If assessments have come due since the date of the judgment, they have to pay that. So if an owner couldn't pay, the $2,000 they owed when the association sent its 209 letter, and then maybe the $5,000 or $6,000 they owed at the time of judgment, by the time you get to post foreclosure, that may have grown, to $7,000 or $8,000, and they have to pay it all at once. There's no payment plan option there that's required. We have some associations that have worked with people on redemption, but they've got to come up with a big chunk of money. And if they were not able to do that up until that point, it's unlikely that they'll be able to do it after the property's actually been foreclosed on. So this talks about when the association buys it. The law also addresses when a third party buys it, and it lays out what has to be paid to the third party. And it also includes if the third party buys it and then pays taxes on it, which I would never recommend that you do. If anytime you obtain a property at a foreclosure sale, you should wait until that redemption period is over before you start spending money, because at any time that owner may pop up and want to redeem the property, or a lender may want to redeem the property. And we've had more than one case where a third party buys the property, they get contacted by the owner, and they just try to stonewall them. And we've had a couple owners who have had to get attorneys involved because the third party purchaser doesn't want to play ball. They want to keep that property. They don't want to give it back. But the law says that they've got to give it back in that 180-day redemption period if the owner or the lien holder comes up with the money that's due under the statute. So now we'll talk a little bit about non-judicial foreclosure. And like it says on the next slide, this is typically used by condominium associations. It's a quicker process. If you have non-judicial foreclosure authority, you can foreclose kind of like a lender does. And we'll talk a little about the procedure and how that works. And I should also point out that non-judicial foreclosure is based on an order of a power of sale being granted to the association. And statutorily, that's given to condominiums. There are some non-condominium associations that have a power of sale. And there was a time where some non-condominium associations could foreclose like a lender. But the law changed a number of years ago. And if a non-condominium association, so we're talking about a single family or a townhome that's not a condominium, if they have that power of sale, they can go through what's called the Expedited Foreclosure Process. And what that means basically is you have to file a lawsuit, in effect, to get the court's permission to non-judicially foreclose. Now, when this was passed, and I think it was 2012 or so, the thought was this was going to streamline the process. It was going to make it cheaper. It was going to do away with a lot of expensive judicial foreclosures. But in reality, it really did not work out that way. What we found when we tried to use it was that the courts really didn't know how to handle it. They didn't like it. They ordered us to mediation, which they had the authority to do, or they required personal service, which when the law passed, it didn't require personal service on the owner. It just became a big problem. And so we generally don't use the expedited foreclosure process, except in some cases where it may be beneficial, and that's really on a case-by-case basis. So typically now, when I'm talking about non-judicial foreclosures, I'll be talking about condominium associations. So the appointment of trustee is something that you have to do, and what that is the association board, the board president, the board adopts a document that the president likely signs, and that appoints the trustee, which what that means is that appoints the person that's going to go down to the foreclosure sale on the first Tuesday of a month and actually sell the property. And that document has to be recorded in the county in which the subdivision is located. So that's kind of the first step in a non-judicial foreclosure. A notice of sale is sent. So typically what happens is it's somewhat of a similar process for non-judicial foreclosures. The association sends a couple notices. There's no requirement for a 209 letter if it's a condominium, but typically the association will send some notices that you are delinquent. They send it to the attorney at that point. The attorney sends a couple of demand letters, and then the attorney sends a notice of sale. So no lawsuits required here. The attorney just sends a notice of sale, has to give 21 days notice that the property is going to be sold at the first Tuesday of the next month. And you have to mail that obviously to the owner so that they have that notice, and we always mail those by certified and regular mail. And then you see if that's what draws the owner out to get them to pay. So we'll go on. Again, this is what we talked about, sending the notice of sale, certified mail, has to give the owner 21 days to pay the money or call and work out some kind of arrangement. And then comes foreclosure day. So if you haven't heard from the owner, you go down to the same place, typically where the judicial foreclosure sales are happening. So when you go to the foreclosure sale, on the left side of the room, there may be a bunch of constables auctioning properties. On the right side, it might look like a mob scene, and what that is these trustees that have been appointed, and they're association trustees or they're lender trustees, they're over there selling properties. And what that means for office is the attorney goes down there, and the foreclosure, same date, same times, between 10 and 4 on the first Tuesday of a month. The attorney goes down there with the notice of sale that was sent to the owner, walks into the room, picks a spot, and just starts reading the notice of sale out loud. And people come up and say, what are you selling? What are you doing? Are there maybe people down there, foreclosure sale buyers, that are looking for you? You know, they'll come and ask you, are you from Roberts Markel? You know, are you from this firm or that firm? Because I'm looking to buy this property. And so the trustee reads the notice of sale just as it was sent to the owner, states the conditions of the sale, which means it's a cash sale, starts taking bids, and sells to the highest bidder. And the trustee can bid on the property on behalf of the association. And again, the goal is the same as in kind of a judicial foreclosure. You want to bid up to the amount due and hopefully get that amount so that the association is made whole. And otherwise, you just sell it to the highest bidder. And a lot of times they will give you cash or money orders. So you may walk out of there, depending on how many sales you have, with thousands of dollars in cash, which is always kind of an uncomfortable feeling. There's a redemption period in condominiums, not 180 days like in non-condominiums, only 90 days to redeem. And it's only the condominium owner that has that right to redeem the property. And again, the statute lays out what you have to pay back if the association obtains ownership of the condominium at the foreclosure sale, and if a third party buys the property at the foreclosure sale. And this is kind of the language. This language was actually in place before the Chapter 209 of the Property Code that governs non-condominium associations. And this is kind of where they got the language from. So basically, you have to pay everything back all at once if you're trying to redeem the property for both condominiums and non-condominiums. I think we're almost done. So let's talk about a few pitfalls. Senior lien holder foreclosure. So typically, For condominiums and non-condominiums, the purchase money lender has a superior lien. And if they foreclose on it, it extinguishes the association's lien. So what that means is if you have an owner that owes you $5,000 and the lender forecloses, the association no longer has a lien on the property. So you can still sue that owner and get a judgment for that amount, but you don't have the remedy of foreclosure. And that's, the leverage that associations use is either pay us or we're going to foreclose. If a senior lien holder has foreclosed, you lose that leverage of threatening foreclosure on the property. And a lot of times, if the owner owes you $5,000, the senior lien holder forecloses, they leave the property, you can still find that owner, foreclosed on owner, and sue them, but you're probably just throwing good money after bad. I mean, if obviously they couldn't pay to save their house, they're not going to have the money to pay you just because you have a money judgment against them. And it's not always the purchase money lender that may have a superior lien. It's something where you have to look at the documents, and that's something your attorney does to determine if a lien holder forecloses, are they or are they not superior? The documents may say that anyone with a deed of trust that's filed before your lien comes into place is superior. So that could be a home equity lender. Sometimes the home equity lender is not a superior lien. So it's really very document specific, and you have to determine, reverse mortgage lenders, you have to look and see, well, are they going to be a superior lien holder if they foreclose? Very document specific. Pitfalls is you don't give the proper notice, and the proper notice starts with the 209 letter. So you need to make sure, and it's always good, maybe at least once a year, to have your attorney look at your 209 letter and just bless it. If that's wrong, that's going to be a problem, and that can be a problem pretty much at any step along the way, and an improper 209 letter can be the subject of a wrongful foreclosure lawsuit. So the other condition precedent would be, did you properly turn it over to the attorney like we talked about before? And again, I can't get this message out enough. The initiation of a foreclosure action has to be approved in the open session of a properly noticed meeting. And there's various ways to do that without putting the owner's name and the property address in your board meeting minutes, which you don't want to do because you don't want to share information about someone's debt with a third party. And as you know, board meeting minutes can be looked at by anyone. So there's ways to do that. You can contact our office if you want to talk a little bit more about that. Even when we file the lawsuit and get service, if we go for a default judgment, though not required by law, I don't know of any judge that we deal with that doesn't require that we send a copy of the default judgment to the owner. It's just something they do. Courts don't like foreclosures. They want to give the owner every opportunity to pay beforehand. And obviously, anything else we file in a lawsuit, once a defendant files an answer, we're required to send notice of anything we file to the owner, the defendant. So we've got to make sure that all those things are done and that they're done properly. Another notice that has to be given is before a judicial foreclosure lawsuit is filed. We have to have checked the property records to see if there's any lien holders entitled to notice. Because not only are lien holders entitled to notice after the foreclosure, like we talked about earlier, there's a provision in the property code that says all junior lien holders have to receive a 60-day notice before the foreclosure action. So typically before we send a final demand letter, we obtain a report from a title company, review it to see if any lien holders are entitled to notice. If they are, we send them. No bids. That's one of the things we talked about. You get down there to sell the property and nobody's interested. So, and it may be that the buyers at that foreclosure sale are a little more sophisticated. They've done their homework and they found a $500,000 lien on that property, so they are not interested. So that's always a problem, is that there's no bids, and if the association doesn't want to bid on it, you're right back where you were. You have a judgment, but you're going to have difficulty collecting it unless the association decides, we're going to bid on this property, we're going to own it if necessary, and we're going to evict this owner if we have to. And we have associations that are kind of all over the place. We have some that say, we don't want to foreclose under any circumstances. We don't even want to post them. We have some that say we'll post the property for foreclosure, but we're going to cancel it the day of the sale. We have some that say we'll post it, but we don't want to bid on it under any circumstances. And if you have a constable or a sheriff that starts bidding below the judgment amount, that may result in somebody buying the property for less than the judgment amount. Now, to some association, it's worth it because they're hoping that that person will get rid of the owner that's not paying and they'll start paying. And then we have some associations that are, we want to bid on it, we're going to own it if we have to, and if we win it, we are going to evict that owner from the property. And you can evict before the redemption period is over. And you know, it's always strange of what triggers an owner to finally take care of this. To some, it's when they get the 209 letter. To some, it's when they get that first attorney letter and they see attorney fees on their account. To some, it's when they get served with a lawsuit and they decide, I better take care of this now. To some, it's when they get the notice from the court that a judgment's been signed. To others, it's when they get the notice from the constable that their property's been posted for foreclosure, and that's when they decide to do it. And then there's some that wait until somebody buys it and they get the letter saying, we're evicting you from this property. It's you know, a lot of times owners have the tendency to kind of stick their head in the sand on these collection lawsuits. And the longer they do that, just the more expensive it's going to cost them. And that's why the system is designed along the way to notice them and give them chances all along the way to try to resolve these issues. Contact the association, contact the attorney, get that over with. If the association ends up with ownership, like I said, you know, typically you don't want to do that because then you've got, do we pay the property taxes? If the property's vacant, we need to secure the property. There's all kind of issues. A lot of associations, if they foreclose and obtain ownership, don't pay the taxes, they don't do anything, they sit and wait for the lender to foreclose on them. And that may come within a few months, it may come within a few years. There's no rhyme or reason as to how lenders decide what property they're going to foreclose on. You may have a neighborhood where there's been a vacant property sitting there for a year or two, and you're not sure why the lender hasn't foreclosed. They've made some kind of business decision that they don't want to foreclose on that house. There's a name for those. They're called zombie mortgages, where they're just sitting there empty, and there's really no explanation as to why the lender won't foreclose, because if it's been a year, that probably means they are not getting paid. So, you know, there's advantages to disadvantages to foreclosing. The advantages are obviously you can collect your money. I mean, to me, the best outcome in a foreclosure situation is not that the owner pays the judgment in full, it pays the constable to stop the sale, but that they get on a payment plan that includes everything due as of the date of that payment plan and successfully completed. Because when, in our office, when they ask for a payment plan, we're going to pick up every dime that's owed, post-foreclosure amounts, post-foreclosure assessments, the attorney fees it took to get it to foreclosure, and we're going to put that in the payment plan. And if they successfully complete that, then you may not have to go back after them. You know, there's a question sometimes is if they pay the judgment off, but you spent $1,500 getting it to foreclosure, you're going to have that money on the account, and you're going to have to start another collection proceeding against them for that money. So it's not always clean. There's a lot of things that can happen. An owner can file bankruptcy at any point during this and stop everything that's happening. So there's a lot of pitfalls. I hope I've given you kind of an overview of the foreclosure process and how it works. If you have any questions, you can contact me directly. I'd be happy to answer them for you. And again, I'm also happy to share a memo that we've prepared on how to properly document turning both collection and deed restriction matters over to the attorney for collection. Kyle, if we have any questions out there, I'll take a shot at answering them.
Hey, Cliff. Yes, we do have quite a few questions. I'll start with this first one and answer it myself. The slideshow and presentation will be available and emailed out to everyone in the next few days. All right, we'll move on. So Amy asked, on sending a property to foreclosure and the openly noticed meeting, are the rules any different in developing community/developer controlled boards?
Yes, and I should make that clear, that the requirement to approve sending a property to foreclosure in the open session of a property notice meeting does not apply if the property is under developer control. And just another word on that. So the law says, and they phrase it, initiation of a foreclosure action is what has to be approved in the open session of a property notice meeting. We came across a case from another state recently that had a similar requirement, and the board had board meeting minutes where they had turned it over to the attorney for collection. But the court said that that wasn't good enough because it did not say the board had turned it over to proceed through foreclosure. So it can be a little tricky. And again, we're happy to provide you how to properly document that turning over.
All right, next question. So what options do POAs have when the owner keeps filing for bankruptcy right before the property goes to auction, especially if the bankruptcy's been tossed out of the court and the same actions are repeated over and over again?
So there is, it's hard to believe, but there is a limit as to how many bankruptcies you can file. And that's really something, I can tell you, our experience is a lot of attorneys their response to a bankruptcy is there's nothing you can do. We don't necessarily believe that. We've got a very experienced and qualified bankruptcy paralegal who, if she sees that someone has filed too many bankruptcies within the span of a year, we will go to the bankruptcy court and try to get the court to sign an order saying that even if they file bankruptcy the next time, it's not going to stop the sale. It's basically, we're looking for a bad faith bankruptcy filings. And there is a remedy if somebody files over and over. Now, a lot of people know how to game the system. And so one year the wife will file, and then the next year the husband will file. And so there are instances where bankruptcies can delay things, but bankruptcy doesn't mean that you're never going to collect that money. It may mean that it's going to be delayed for a while.
All right, next question. So for association boards, what happens if they're not notified of the sale or the price they're sold for? Are they out the money that they're supposedly owed? What happens then?
So read me that question again.
So for an association board who was not notified of the sale or the price the home sold for, are they out the money that they are for the past due assessments?
Well, I'm not sure I understand the question, but I mean, anytime that a sale happens, the board should know that it's happening. If you don't know that it's happening, it means that there's some miscommunication between you and your attorney. I mean, a judicial foreclosure sale, or even a non-judicial, those don't happen unless the association makes those happen, makes that stuff happen. So there should be an instruction to the attorney to go down and sell it on a non-judicial if you're a condominium, or if there's a judicial sale, it means that the attorney has put that in process. So if that happens and you don't know about it, I mean, the association's still entitled to the money from that sale. So you don't lose it. I mean, if a sale happens and money exchanges hands, the association's entitled to its portion of that money. And if that doesn't answer your question, you may have to contact me directly to give me a little more detail on what you're talking about.
All right. Next question. If a homeowner has been foreclosed upon and they repurchase their home on the courthouse steps, does an association have a faster way to proceed with enforcement if they are again past due on assessments for the association?
No. So, when you get a judgment, it captures the amount due on a date in time, the date you file the motion. So you file a motion for default judgment. There's an affidavit in there that says, as of March 1st, 2020, this is the amount due. So if the owner somehow reobtains ownership of that property and they don't pay the 21 and 22 assessments, you've got to start the collection process again and get another judgment and pursue them again.
All right. So next question. How or does the Homestead Law /Act come into play? I was advised by a non-HOA attorney that you cannot foreclose on someone's residence /homestead.
So an association judgment, generally speaking, is an exemption to the prohibition against a creditor foreclosing on a homestead. There's some issues there that are somewhat complicated regarding when the lien was created, but typically the homestead doesn't stop an association from foreclosing on a collection judgment. And again, sometimes that takes a thorough review of exactly what the documents say, but generally a homestead doesn't stop an association foreclosure. So, other exceptions are a lender for a purchase money foreclosure, or a lender foreclosure, a mortgage foreclosure, or the taxing authority foreclosure. The homestead doesn't protect you from those foreclosures. Generally speaking, it doesn't protect you from an association foreclosure for secured amounts in an association judgment.
Okay, next question. So this person asks, please clarify if all accounts must be approved in an open board meeting before being turned over to the attorney, or if only accounts that are up for foreclosure.
I would turn over all accounts. And I would use language that says, we're going to, for example, you make a motion to turn over every account with a balance of over $500 to the attorney for collection through foreclosure if necessary. And so that doesn't mean you have to foreclose, but that means initially when you turn them over, you've got your board meeting minutes that's authorizing foreclosure. How you want to proceed on foreclosure is a conversation between you and your attorney. We have some associations that want us to ask permission before every step of the way. We have some that say, we don't want to hear from you again until you have our money. Do we just want you to go? Now, even in those, we will typically ask before we post it, just because in case the board knows something about that owner, knows there's some issue that there's no way that we could know about. But I would approve any account you're sending to the attorney. I would approve that in the open session of a property notice meeting. And again, an exception is if you're under developer control, that's not a requirement.
All right, next question. So if the HOA does not bid on a foreclosed property and there are no other bidders at the auction, do we automatically repost the sale?
You can repost it, and the order of sales are only good for a specific number of days. I think it's 90 days. So depending on when that was issued by the district clerk, you may have to request that document. But the constable doesn't automatically repost it. That's an action the association would have to take, or the association's attorney, to repost that property. And again, if that happens to you, even after the first time, if there's no bidders, you've really got to think, do we want to spend the money to repost this again? And if we do, are we going to bid on this property and do what we have to do to get this person out? Now, if that's a vacant house and it's been vacant for 6 months, I don't know if I would do that. If somebody's living in the house, and especially if it's the owner's homestead, those people need somewhere to live. And some people aren't going to leave until someone with a gun shows up and says, a constable preferably, and says, you've got to go, you're being evicted. And that might be when their trigger point is when it really happens that they're going to try to take care of it. So, that's another thing to talk with your attorney about is explain the situation of the house, and, you can get some advice on should we bid or should we not bid.
All right, what options are available to an HOA if an owner defaults on a lawsuit judgment?
Well, if it's a collection judgment, hopefully it has foreclosure language in it. And the default, if they sign a judgment and then default on their payment plan, if you've got foreclosure language, that's your option, or that's an option, is you've got the leverage of foreclosure. And so you tell them you've defaulted on the payment plan. For our payment plans, we typically send at least one default letter and say, hey, you missed a payment. By the next month's, the date the next month's payment's due, you owe X amount, which will include everything due as of that day. If they don't pay that, we then ask the association, do you want to post it?
All right, next question. What can an association do when the homeowner only pays the bare minimum to stop the foreclosure, but doesn't pay off all monies owed?
So that might be, I guess, a couple of different situations. Some owners only pay the assessment amount, and by law, you've got to apply it to the assessments, and they may have attorney fees on there. You just have to keep going. Some owners may pay the constable the amount they're being quoted by the constable if the secured amount's awarded in the judgment, but like we just talked about a little bit, you've got another $1,500 by then that you spent getting it to that point. You've got to start another collection action. And that's very frustrating. We know to the boards is that it seems like it never ends. They pay some and then they get another attorney fee bill. And that's why I said earlier, the best outcome to me in a foreclosure is when the owner gets on and successfully completes a payment plan that includes everything due as of the date of that payment plan. Because sometimes it can be kind of a never-ending struggle of making demands, getting small payments, and then having to keep going and going.
All right, next question. So if an association files foreclosure on a property who owes, in this scenario, $20,000, but the property only sells for $15,000, is the association out/required to eat the $5,000 difference?
Well, I mean, obviously you're not going to get the amount of the judgment, but the judgment is still out there. So the abstracted judgment that I talked about that's filed that says they owe $20,000, that's still sitting out there. And let's say if the association's portion of the foreclosure sells $15,000, there's now a $15,000 credit to that judgment. So the abstract's still out there. If that person goes and tries to buy another house or gets some type of a loan where the lender looks and finds that abstract, they're going to want it paid. But it becomes much harder to collect because obviously you've already foreclosed on their house, so that leverage is gone. You'd have to try to find something else you can sell. Texas is a very good state to owe money in. The law allows for a lot of exemptions, exempt property. But if you can find another piece of property they own, a rental house or something, you can go after that to try to collect that balance. The judgment's good for 10 years, and it can be renewed for additional periods of 10 years, but there's some actions you have to take to keep extending that judgment. But without the leverage of foreclosure and something to foreclose on, it becomes a collection issue and it can be difficult to collect.
All right, here's another question. Will the constable's office let the HOA know if there were no bids on the property?
They don't let you know, but if you call them, they'll tell you. So, typically your attorney may be at the foreclosure cell to try to determine what happened. But if not, sometimes if we only have foreclosure cells that are no bids, meaning the association said we don't want to bid on it, we may not have someone down there, but we always call afterwards and try to find out exactly what happened. And I think now that's even online where you can find out what happened with the sale.
All right. I'm actually going to ask a question of you, Cliff. So what happens for, say, a rental property in an association? Can the association become involved in an eviction? And second part of this question, if the original owner of the home is not paying their assessment, what action should the association take if it's being rented out?
So, it's just the same with the deed restriction violation. Even if it's the tenant, your remedy, the association's remedy is against the owner. So you pursue the owner. If it's a renter and you're not getting your assessments, you pursue the owner, and the owner will call and say, well, they were supposed to pay that. And your response is, well, they're not. And if you don't pay it, we're going to have to file a lawsuit and if necessary foreclose. Now, if it's a rental property, that means it's not a homesteaded property. And that means the constable, when they go to foreclose, can collect not only the amounts that are secured by the lien on the property, but any other amounts in the judgment that are not secured by the lien. So if you've got some attorney fees or maybe some fines and your documents don't secure those amounts, if it's a rental property that's not the owner's homestead, the constable can collect all that money. And I guess just on the matter of homestead, the appraisal district is a good guide as to whether a property is a homestead, but it's not the final determining factor. There are actually some owners out there who, for whatever reason, have not homesteaded their property with the appraisal district, which gives them a tax break, but that doesn't mean it's not their homestead. If they're living there and even if they have the intent to return and live at that property, it can be considered their homestead, whether or not it's designated as a homestead in the counties, in the appraisal district records. With regard to evictions, so there's some protection, federal protection for evictions out there, and I believe it's still in effect. And it's really applies to people who receive federal rental assistance, If you're in a federally subsidized housing program, or if your house or apartment building has a federally backed mortgage, there's some protection from eviction. It's not automatic. There's a step that if you're that person being evicted, you have to take by filling out a form and presenting it to your landlord. We've heard kind of mixed stories. We've heard that some judges are evicting the people that the law allows them right now to evict. We've heard that some judges are hesitant to evict anyone. So it really depends. And you know, sometimes when you're an attorney, you find yourself in the position of having to try to educate the judge on really what the status of the law is. So it really depends on the particular situation. But generally, associations are not prohibited from evicting people. Now, you know, eviction and foreclosure, there's always the question is, just because you have the authority, should you exercise it, especially during these times? So when it really comes down to, you know, evicting and foreclosure, you just need to think is, do we need this money that badly right now? Can we wait? You know, we've had a lot of associations that said, we're not going to post anybody for this year. And these are ones that typically are, let's post them, let's own it if we have to, let's evict them. So it's really, everyone has to kind of look at their own situation, every association, and determine how they want to proceed in these kind of crazy times.
All right, we have two more questions and then we'll wrap up. Which constable's office conducts the foreclosures? And I don't know, maybe, is it all of them, or will it differ from county to county?
It differs. You know, in some counties it's sheriffs, and some it's constables. Typically, you know, like in Harris County, where there's a lot of different precincts, you want to send it to the constable that is the precinct in which the property is located. You know, the problem is that some of them are better at it than others. Some of the constables require that you pay cost up front. Some don't. Some will wait. And let's say if the association forecloses on it, their bill for their costs, they'll wait and hold that and send it to you afterwards. So it really just depends. You know, like I said, the practices are different all over the place of how the constables do it. If they start bidding at the judgment amount, or if they start at their cost, you just got to kind of get to know the constable of the county in which you're trying to, or the sheriff in which you want to foreclose on a property, and figure out what their practice is.
All right. So can you proceed against other property that is not real property to collect an unpaid judgment amounts, such as garnishing wages, etc.?
There's ways to do that. It's difficult. You know, if you can locate, you know, somebody has a boat, I don't think that's exempt. You know, you can try to tell the constable, hey, they've got a boat, this is where it is. And that's one of those situations where you need to provide as much information as you can to the constable to try to seize non-exempt property. You know, the list is kind of crazy in Texas. I think it's 2 or 3 guns you can have that you can't be seized and sold. You know, things like that. There's a way to try to get money out of people's bank accounts, but it's fairly difficult in that first you've got to locate the bank account, try to determine if there's any money in it. There's some services that aren't necessarily 100% accurate. And then you have to go through a procedure through JP court to try to get the bank to freeze that money. And we did it a few times, but it seems like in most cases, it was costing more than it was recovering. So there are options out there, but they really become difficult, or can be really difficult.
All right, so one more question came in, and I think it's a relevant one based on what we were talking earlier about having money or a property sell for less money than what the association needed to pay the past due assessments. What happens if a property is sold at foreclosure and it's brought for more than what it's due?
So let's say you got a judgment for $10,000 and the property sells for $20,000. The constable is going to take some money out of that $20,000, their cost. They'll deduct that. They'll then send the association the amount of the judgment. The rest of the money is called excess proceeds. And typically what they do in a judicial foreclosure is they take that money and give it back to the court. And then, excuse me. And then what happens is people that have a claim on that money, including the foreclosed on owner, can make a claim to the court for that money. I have heard of a couple instances where the constable actually sent the excess proceeds directly to the foreclosed on owner. In a non-judicial foreclosure, let's say we go down there, I go down there, and in the same situation, I sell it for 20,000 and they only owe 10,000. We have to write a check to the foreclosed on owner and send them that excess proceeds.
All right, that does it for questions.
All right, well, thank everybody for coming, and you can contact us directly if you have any questions.